All right, thank you guys. All right, so hi, my name is Mike Rubi. My company is King of Evictions. We've been in this industry. My dad been in the industry over 40 years. I jumped on when I was 15. I'm 36, so what, 21 years I went in the industry. What I do the evictions. I'm here to help you guys out. We have a referral program where you send us clients, we give you $100 for referrals. We're here just to, like I said, the difference between us and an attorney is that we're allowed to walk in summonses and get summons the same day. An attorney, they can't do that. They got to e-file stuff. They need to go by the portal. Sometimes the clerks are real behind and you lose about 3 weeks. I save about 3 weeks. How can I, so when I started this business, my dad taught me how to do the roast, and then also at the time, the chief judge at the time was Judge Farina. My dad took me to the courthouse, but like I said, my dad was in the court for 40 years. So the chief judge goes, "You want to make money?" I'm like, "Yes." He goes, "Learn this business." So he actually taught me how to do the evictions where the judges don't question evictions. You don't need an attorney. That eliminates all that. So what judges hate me is because I've been doing this for so long and I've been doing this for so right that it doesn't give time for the tenants to get an attorney, fight the eviction, and our process is to get these judgment signs within 23 days. We get judgment signs in 23 days, and the attorney takes about 2-3 months to get judgment signs. The difference is that when you guys go to these events, and it happened that attorneys lie, or you have to use an attorney. You have to use us. And that's the reason why we're not getting business, because you big company managers like you guys think because an attorney said you have to use them, you guys don't want to listen to people like us. And it's not true. The law says that the only way the tenants have the right to respond is to contact the landlord first, try to pay them first. If they say no, then go to the courts. They have to put the court in the registry or hire an attorney to have a hearing. If they don't do that, the case is over. We do a motion to strike, the judge signs it, and we go on to our next cases. Yes, we use Steven sometimes because tenants do respond. Tenants do get an attorney. And that's another thing. What I've been seeing with the 3-day notice. Okay, so in eviction, the most important thing is the 3-day notice. If that little piece of paper is wrong, the whole case is wrong. Doesn't matter if I do the complaint right and the sum is right. If the judge sees that little piece, and see right here, if that 3-day notice is wrong, the whole case is wrong. That means that you have to file the case again. That's why I always tell clients, don't when you have tenants, call me. Let me do your 3-day notice. And that's another thing. What difference between me and you guys is when you guys do your 3-day notice and take a picture of the door, the tenants could respond, get an attorney, be like, "I never got the 3-day notice." And because you guys don't have no proof, pictures, yes, I understand pictures, that's what everyone's doing that, but what's going on, what I've seen is the owners going to the property, putting the 3-day notice on the door, taking a picture, and then bringing the 3-day notice down. So tenants are not getting them. And because you guys don't have an affidavit saying that they're actually getting it, the judge has to dismiss the case automatically. And you got to refile the case again. With us, we do a 3-day notice. We do an affidavit because I'm a court officer, I'm a prosecutor for the courts, that said, "Listen, judge, I served the 3-day notice. I posted it." So if they get an attorney, the judge is going to want to have a hearing, want me to go in front of them. And I'm like, "Judge, I'm a court officer. I put it." The judge has to agree on what I say more than the tenant, more than an attorney, and more than anybody. Like I said, this is basically that's what we do. We're here to help you guys out. Our goal is to take all these evictions from these big property managers that you guys might know, recommend, because like I said, these attorneys are lying to you guys saying that you need to follow with them, and come to our side. We have an attorney that handles everything, that doesn't even charge you sometimes for free advice. If you call an attorney, they're going to charge you either $200 or $300 off the rip for each hour. We don't do that. We're here to help you guys out. I don't know if that's, am I missing anything else?
No, right. So to be clear, the law allows a property manager to file the complaint. So Mike is obviously not an attorney. What he does is he has the forms ready and processes it for you, right? And he will process it for you much faster than I can as an attorney, because I have to e-file it. I have to wait. I just filed a case. I had to wait 3 or 4 days just for the case number. And I can't even serve them. By the time he's already, the case is filed, served, and the countdown has started to the tenant to put money in the registry or answer, I still don't even have a case number. So it is true the way that works. And if it's an individual that owns a property, technically they never need an attorney because they can represent themselves. If it's a company that owns a property, what the law says is when if the tenant responds and disputes the case, then you're obligated to get an attorney. And that's when if one of Mike's clients decides, well, I'm going to file myself as a property manager because the law allows that. When the tenant then responds, if they do, most of the time they don't. There's a good chunk of cases that just go to default, and those go very quickly because of the way he handles it, processes it. Then I would have to get involved, and I file my answers, and we try to push it as quickly as possible. The biggest thing that happens, and the biggest mistake, what Mike said, that happens is the 3-day notice is wrong. That's the biggest mistake of an investor, property manager. If you're helping clients manage your properties, is a 3-day notice. Mike, does you do the service of posting the 3-day notice? Well, number one, whenever someone tells me I need any type of notice posted, I always say, well, we should have a third party do it because then they can't say, oh, I didn't get it. That argument's not there because he's a process server, he has an affidavit, and the law says that if the return of service, which is what he signs, the affidavit, if the return of service is good on its face, there's no mistakes on the face of it, the court is compelled to see that as true over almost anything else. So you get rid of that big risk of, oh, I never got the notice. And the other people say, well, I can mail it too. Yeah, you can, but then it adds days. It adds an additional 5 days when you mail it. Because if you post something and mail it, the law doesn't say, well, if it's posted, we'll go through that. The law says, no, we have to give an extra 5 days because that's how long it takes to get for the mail to go throughout. So you want to try to only post, and you want to get rid of the risk of the tenant saying, I never got it. And that's why you hire someone like Mike who can post it for you, get it done quick. I mean, he's done things, do it the same day.
I'm gonna show you guys. I got a judgment signed. Okay, I'm gonna show you. I'll show you right now. Look, I'll show you right now. Like I said, this is only the branch courthouses. If it's downtown, my dad retired from the courts for 3 years. So the new judges, like my dad was, let me tell you who my dad was. My dad was the face of the courthouse. So all the judges that came in first, when they first became in, they had to run into my dad. My dad had to screen them, get to know them first, and then put them in the courthouse where he thinks that they belong to. So all the judges had to go to my dad first. So that's how we, and my dad's into politics. So my dad's into that politics where he's into all the judges. So all the judges are my dad's best friends. So my turnaround right now, I'll tell you right now. You guys could Maria. Okay, look. I want to show everybody. I filed this on 6/26, and I got a final judgment on 7/15. Less than 3 weeks. Right? Ask Steven if he could do that.
No, it literally is impossible because the way it works for me is, like I said, I gotta file online. I gotta wait for the court. I gotta wait for the case number. Then I still have to call Mike. He needs to go and get the summons. Then he serves it, right? And then even if everything goes perfectly, I then have to file another document with the clerk. I gotta wait 2
less than 3 weeks.
more days, depending how busy they are. Business days. If there's holiday, it gets even slower. For the clerk to stamp the clerk default. Then I got to go to the judge. And the way the judges work for attorneys is it's not like what he does. He has a packet and puts everything in a pile. The clerk takes it. I have to do it all online. And we have this basically an email system between attorneys and judges. I give it to the judge. It's in their email. I have zero control when that judge will sign it. I honestly, it's frowned upon to be calling, hey, I need this done. You got to give it at least a week. So it is 100% true. If there is no response, you will get a quick turnaround trying to do it what's called pro se, right? Because again, Mike's not an attorney. All he's doing is helping you guys out.
I don't sign. You kind of signs the paperwork. Right. Another thing when I was on the 3-day notice, I get 3-day notice where I get it today, and I see that the date was been 3 weeks ago. You guys can't do that. The law says in the judge's eyes, the judges are dismissing the cases because in the judge's eyes is you guys should know if you guys are ready to file in 3 days or not. It shouldn't take 2 weeks for you guys to decide if you guys are going to file or not. Because I get clients that they don't, for example, a guy named Frank, ask him. He gives me a 3-day notice that's 7-8 months. So what's another thing is that legal services now is because listen, remember now all your phones, all you gotta do is Google how to beat an eviction. and they'll tell you step by step how to beat it. And all you gotta do is put a legal service that they're free,
Yes.
answer the case, and fight it. And if you lose, guess who pays the attorney fees? You kind of have to pay the attorney fees. I have a client right now paying $10,000 in attorney fees. Ask them,
Yes.
Michelle. And I'm sure we're trying to get out of it. We can't. That's why I tell you guys, guys, once you, okay, I'm gonna tell you what a judge told me when I was a kid. I never understood it because I was making money, going out with friends, and I didn't care. But when I got older, I realized it goes like this: if you guys are in this for the money, then you can have a heart. When it's time to pull the plug, you have to pull the plug and do the eviction. If you're in it for the money, or if you like to help people out, get out of this business and go to customer service and help people out because that's the type of person you be. But in this business, you can't have a heart. You don't fall in love with your tenants. In this game, you cannot fall in love with your tenants because these tenants, if you give them your finger, they're gonna take your hand. Okay? Partial payments, don't accept it. They sell you, oh, but there's Zelle. Send it back with a follow text. We're not accepting partial payment. You either pay in full or do not pay or go to the court and pay the court when it's time for the eviction. The court's not gonna accept partial payment. They will accept full payment only. And plus, they hold a fee, an extra fee for you to keep the money there. I think like 7% interest rate, right? 7%?
They charge
Or 3% or
yeah,
7%?
3%. They charge a tenant around 3%. It's like a sliding scale. The more money, the lower the percentage. But yeah, so if the tenant has to put in $1,000, he actually has to deposit like $1,030.
And they don't do that. Because they're like, why would I pay if it's my so they don't do that. So
So-
that saves us that gives you a benefit to sign the judge tonight quick.
Right.
No, these people know, like I said, these people notice, I see that it's like months and months. I'm like, why?
Yeah, so and we share a client that we have that issue where they'll send a 3-day notice that has like 9 months of payments missing. That doesn't work because then the tenant can easily refute and say, well, look, I made this like partial payment on 3 months ago and this payment, and you got to be consistent. And I would say maximum 45 days to 2 months, but really you have to for the investors, the property owners, they got to be on the ball and say, listen, if my release has a 5-day grace period, on that 6th day I'm sending out 3-day notices, or on that 8th day, the next business day. And the case goes much smoother when you're only asking for 1 month or 2 months of rent, because then it's easy to prove that the payments aren't there, especially when you're dealing with public housing, especially when you're dealing with tenants that paying cash.
HUD, right? HUD, another one, right? HUD's another one.
HUD, and
HUD.
especially when you're dealing with tenants that pay money orders, right? It's not as difficult when you have all the proof in checks or electronic deposits, but a lot of tenants, I own a duplex. Sometimes you have a tenant, oh no, I don't have the check, but here I have the cash. And then, oh, I gave them cash. So the quicker you react, the easier the case will be. And then if the easier the case will be, the quicker you can get them out. The one thing in Florida that we have, and if you have out-of-state clients, people from New York, California, whatever, that are looking to buy, and whether it's looking to buy residential and there's a tenant in there, right? Everyone gets spooked, right? I always have that. I have clients that want to buy properties, and the realtors say, hey, can you speak to them because there's a tenant in there, they don't understand. They have horror stories from New York and California and other states where evictions can last a year, 2 years. That doesn't happen here because it's called pay to play, right? You have to, at some point, the tenant has to put money in the rent in the court registry. There is a way to delay it though.
Yeah.
You can file them, and the tenants know this, and it's all there online. It's very
Like I
easy
said,
to
it's
do.
so simple. It's not like it used to be where they
Right.
used to figure out how do you do it. No. And one thing you have to understand, these tenants are not your friends. These tenants talk to tenants. So if a tenant, I don't know if I evicted one person 8 times in 1 year. And I didn't know she was jumping from my phone from where I do evictions from 8. And I was like, how? Because they talk. They're friends. They're not your friends. And like I tell you one, if they see that you guys are soft, they're gonna treat you. They're gonna take advantage. They're gonna treat you. But if they see that you're hard and you be like, oh no, day 5, I'm putting a 3-day notice. Trust me, you'll get your money. In this game, you shouldn't be chasing your money. I see realtors. Oh, they haven't paid me. I'm like, why? You have the ball in your court. Put a 3-day notice, and if you want to get respect, put a 3-day notice. And you see how much they pay you. If they don't pay you, then we file eviction. And at that point, you get them out, and then you get respected. And trust me, everyone will be like, don't play with this guy. If you're gonna move it, you better make sure you better have the money on day 5. Because if not, these people do evict, and you will see how faster you'll get income, and you will never have to call me. That's the key. Is not calling me. The key is helping you guys out. Where you guys have your another thing. If the rent, and I've learned this in the year, if the rent's 4,500, tell your clients, hey, listen, take $200 off. Don't do it market. If you do less than the market, trust me, these sellers won't even bother you. They'll fix their problem themselves. They'll pay you because they'll be happy, like, well, everywhere else is 45 and the only probably you mean 42, and they'll be happy. And then it'll be a nice, smoothly process. But if they see that you go put a 3 notice today and then wait 2 weeks to file the eviction, they're like, oh, this guy can take advantage of this guy. These guys, they're never going to file eviction, and then they will never pay your rent. And that's not the point. The point is to make sure you guys get your money on time. That's it. Trust me, if you guys get your money on time, everyone will be happy. And I'm telling you, I'm losing money. I'm telling you, I'm going to lose money. I'm doing this, but that's how I am. I teach my clients and teach them how to do this the right way. My goal is to take all these property. I know you guys don't want a lot of property managers, and all these property managers use their attorneys. Take it from them. Give it to us. Now you'll see the income and the results will be a lot quicker and a lot happier than they're using whoever they're using. That's the reason why we're here for, to help you guys out. What's up?
How can a 3-day notice be incorrect?
Because you have to put 2 dates. Number one is the dates. People put like today's date, and then the third day they'll put today's date too, and it's wrong. That's number one. Or they'll put today and they count Saturday, Sunday as days, and you can't do that. Or they count or federal holidays as one day, and you guys can't do that. The law says you have to count only business days and working business days. Not federal holidays. If you guys count that, that's it. That's wrong. So you have to make sure the dates match when you file the case. Right or wrong?
No, yeah. And honestly, the biggest mistake I see landlords make, other than the dates, is adding late fees. The vast majority of leases do not have late fees as rent. You can only evict for rent. You can't evict for late fees. You can't evict because he owes you $300 for a repair. Those are breaches of contract, which you could get an eviction as well, but that's a lot more complicated, and that's not with a 3-day notice type of case.
If you guys want to send me your address, I have a statute where if you guys put in your lease agreement, then you could add late fees. You could add, but remember, there's 2 sets of laws. You guys have your own laws, and you guys have your own real estate law, what they follow. But we have court laws, and what judges go by court laws, not by your laws. So your laws doesn't mean to when it comes to courts. So if you guys put the Florida statute law where you guys could add late fees and anything else and collect security deposit that you never have to give it back, then you're safe. But a lot of times I see it, oh yeah, but they have security deposit, I'm gonna stay with it. No, but your lease doesn't say you could keep it. If they sue you, you're gonna lose.
Right. So honestly, I just even when my clients have the late fee language, I tell them just base rent. Just put on the rent. What the language is in your lease, you have to put somewhere in an addendum clause, late fees shall be considered rent. If you put that in there, and you can go out, then you can ask for late fees. And then so remember, one thing I don't know if Mike he talked about it, but not in detail. When you post a 3-day notice and the tenant has the money, let's say you post a 3-day notice, $1,500, and the tenant goes to your client the next day, or if you're the property manager, goes to you the next day, and here's $1,500, you have to accept it. You can't say, no, I don't want you guys anymore. Go away. You have to accept the money. It's illegal to deny within those 3 days, but only if it's the full amount. So that's where you get into trouble, because some tenants are saying, well, I'm going to charge $1,600 because $100 late fee, and they come back with $1,500 saying, no, this is my rent. No, the late fee. I want my late fee. Late fees can't be collected as rent unless it's in your contract. So honestly, $100 isn't worth it, right? So you either just collect the rent and you can add the late fee later, and you can, when the tenant vacates, you can make a security deposit claim on whatever they owe you, right? Including late fees, but it's not worth it to mess up an eviction, because then what happens if the tenant has the money, they put the money in the court registry, right? Say, judge, I had the $1,500, they didn't let me pay, I'll give it to the court. And then if that case goes to trial, and if the tenant hired an attorney, that landlord's going to lose, and that landlord's going to have to pay for the tenant's attorney. And it goes the other way. If the tenant loses, the tenant technically, if the landlord ends up getting an attorney, right? Because you don't need one right away. The tenant would have to pay, but the tenant not paying rent doesn't have money anyway.
Another thing I see also is that you guys accept partial payment. Once you put the 3-day notice, you guys accept partial payment. If you accept partial payment, the 3-day notice is now invalid. We have to put a new 3-day notice
Correct.
with the new amount.
Correct.
So that's why I tell them if with those 3 days they come with half the money, don't accept it. This is what I tell my clients: accept all or nothing. Because if you accept a dollar, that 3-day notice has to be valid. We have to do it, and then I'm going to charge you $250 again.
$1. That's correct. $1.
So do not. So if they come, they're like, I have a dollar, I'm going to accept it. Then you know what, Mike? They pay me a dollar. I'm going to be, listen. I'm sorry, but we have to do now the new amount, and I got to take out that dollar. So that's what I tell my clients: if they will come with no money or partial, don't accept it. Let them go to the court and let them figure out. Let them pay the dollar to the court to see if the court will accept it.
Right.
Don't accept. And that's another thing you guys say. I see you guys accept the partial payments and then call me, hey Mike, I have an eviction. I'm like, oh, what? They paid me $200. I'm like, you accepted? Yeah, I accepted it. Can I send it back? No, it's too late. The law says you have 24 hours to send it back with the following text that you're not going to accept if it's partial. If after 24 hours you guys send a text message, that means you guys send with the money. You guys cannot send the text. Because they'll be like, Judge, listen, it took 48 hours for him to say that I'm not going to accept it. So the judge is gonna be like, no, we have to dismiss the case.
And that's an issue when you have clients that send rent via Zelle, electronic deposit. You got to try to return it right away. Even just telling them you're returning it and getting a check out and returning it, right? And that's for partial payments. If they send the Zelle for the full amount, obviously you got to accept it within the 3 days. But once the 3 days notice is up, let's say the 3-day notice ends on Monday, that means Tuesday midnight, you don't have to accept rent anymore. And you can make a determination whether you want to accept rent or file the eviction. You can only file the eviction after those business
The 3 days are
out,
out.
right? But then you do not need to accept rent. So if the 3-day notice ended on Monday and the tenant comes to you on Tuesday morning and it's a tenant that you don't want anymore, or you know what, the tenant's in a great lease and I think I can get double the rent, you don't have to accept the rent anymore. And that's a determination of the landlord whether they want to do it or not. But the law only requires you always to accept full payment of rent anytime before a 3-day notice is filed, right? And anytime within the 3 days. So before you file a 3-day notice, let's say the tenant's 10 days late, right? But you haven't done a 3-day notice yet. And the tenant comes on the 11th day, you have to accept rent. You can't say, no, you're 10 days late, I'm not going to accept it, because you have to post the 3-day notice first. The only time where you don't want to accept rent and you don't have to accept rent is obviously after 3-day notice, or if you believe the tenant is in default of something else. For example, the tenant has a pit bull. Your lease doesn't allow any dogs, but especially there's a pit bull in there. It's a huge liability for you as a landlord, right? You actually should not accept rent, because if you posted a notice, and we can talk about a 7-day notice. So those 7-day notices, obviously, we help prepare. Mike serves them those complaints. If it's an individual is always allowed to file a case by themselves, pro se. What the law says is, though, property managers are allowed to file pro se for 3-day notices, right? Other types of evictions, such as a 7-day notice, can't be pro se.
We still do it, and then it goes away with it, but
Right.
we can't. So we just go by it, roll by the punches, and if anything, the law says the attorney could enter the case at any time. The only thing we gotta do is do a motion of appearance. The case not gonna dismiss. If I file it, don't think, oh, because you filed it, we did 7-day. No, it won't get dismissed. Steven will get in, motion of appearance, and then Steven takes over. And then from there, the judge will grant it, and then we'll take them out. Well, with 7-day, you cannot accept rent.
Right.
If you accept rent with the 7 days, I mean,
Right.
that
Once
7-day
you
notice.
post, right. So there's 2 7-day notices. There's a 7-day notice that says it says with cure, right? So for example, you have a dog, you're not supposed to have a dog. I want your dog out. Again, for 7-day notice, you would want to call Mike. Mike usually calls me. Both of us are on the line. I usually prepare it. I charge a fee to prepare the notice. He charges a fee to do the service, because again, it's best to have a third party do it. So there's 2 types of 7-day notices. There's a 7-day notice with cure. Which is the most common type of 7-day notice. That's a notice that you're giving the tenant an opportunity to cure the default. You have a dog. You have the boyfriend that's not on the lease. You have it listed on Airbnb. Okay, something like that can be cured. Take it off Airbnb. Get rid of the dog. Boyfriend can't live there anymore. when you post that notice, you cannot accept rent. Because if you accept rent after posting that notice, that means you don't care about the default anymore. You waive your rights. The other 7-day notice, obviously you can't accept rent in this one, is without cure, which means I want you out in 7 days. Of course, if you're telling somebody I want you out in 7 days, you can't accept rent anymore.
And you have to approve because they go to court. They want
So
they
yeah,
want to
that's
know why.
That's why I get involved in the set. 3-day notices are simple. You put in the facts. Usually the property managers, with Mike giving them the form, can fill that out easily. The 7-day notice has to be more specific because they're much harder to prove. You have to say exactly what was going on, what's the problem, what's the breach. It's pretty rare to have a 7-day notice with no cure. It would be something like a violent event.
Yeah, like someone bought a
Right,
gun.
they destroyed my property. It has to be something that they can't fix it within 7 days, right? I do them sometimes. The most common thing for me is a tenants that were violent, got arrested, assaulted another tenant, things like that.
Smoking marijuana in the property that they can't.
Yeah, illegal
Stuff like that.
activities, things like that are the most common 7-day without cure. And then with the 7-day with cure, let's say the dog comes out, you check it. Okay, dog left, great. I'll accept your rent now. A month later, the dog's there again. You don't have to give them 7 days notice to get. You can just say you're out. 7 days, you're out. Because if they violate what they previously cured within a year, you don't have to give them another chance to cure. You just file and get them out. So and I want you guys, your clients, your other realtors, we take calls all the time where we just answer questions and then hey, give us a call back. Let us know. Like we're not charging for answering those questions. There are lots of times where we say sorry, like you explained it. There's nothing we can do. And
like I said, if I can't, trust me, I've been doing this for so long. If I can't do it, no one could do it. Don't look for someone else because someone who might say yes and they might just take your money. Yeah. And then you're gonna call me back, Mike. I should have listened to you. I'm like, I told you guys. And also another thing. Now we're talking about. Let's go with 30-day notices.
Yeah.
30-day notices is those are notices 1 to 10 or month to month, not leases. Month to month. Once the lease is expired, they become month to month. So at that time, if you want your tenants out, then we have to give them a 30-day notice. The 30-day notice has to be done on the first of the month. If you do it after the first, you gotta let them finish the month that they're on, plus give them a new 30, whole 30, because it will start on the first of the month to the following month to the end of the period. And after that, you can file it on day 2nd. I filed it day 1 and I got in trouble, right? So I always wait. Now I wait day 2 to file it.
So right. So month to month is, and there's still people that believe. I don't know if you guys remember during COVID, the counties started changing their own laws. So before COVID, you only need to give 15 days notice. And then Miami-Dade County, Broward, Palm Beach, Orange, all the big cities started saying, oh, no, that's not enough. COVID, it's crazy. No one can find a place to live. You got to give 60 days now. And a lot of people still think that's the law, but it's not. Right? In 2024 or 2023.
2024 January.
The state legislature changed the law and said, no, counties aren't allowed to regulate these type of things. It's 30 days now. But what does 30 days mean? It doesn't mean that it's May 3rd and you're going to say, well, I want you out by June 3rd. No. It means 30 days before the start of the next rental period. So right now, it's April 25th. If your client said, I have a month-to-month tenant, I want to get them out, you have to give them notice prior to May 1st to get them out by May 31st.
But it's also good because in the judges in our defense, we'd be like, Judge, the law says 30. That's why I was telling you, if you have a 30 notice, give it to them probably 15, 20 days before.
The more days, the better.
Because if you give it to them, then they don't look for a place and they try to fight it, be like, Judge, the law says 30, but we actually give them 45. Then they still don't look for a place. And the judge at that point is going to look at him and be like, you're the idiot for not looking for another place. They did the job right. And then that's it. The default has to be entered.
Correct.
That's why I tell you, if you're going to have a 30 days, give it to them 15 days before the end of the second period. So by the end of the following month, we could evict them.
Correct.
And you accept payment. That's with payment. If they don't pay, we can give a 3-day notice. If we give it to them, for example, today, and next month you say that on the 5th they don't pay, call me, Mike, they didn't pay. We give a 3-day notice. And at that time you have 2 options because you have a 3-day for payment, and then if they pay you, great, because you saw the 30 days running. So and then at that point you can file the eviction and you got your money, and then the following month you don't have to accept money after that.
Right. So a lot of the biggest concerns on some month-to-month tenants is, or our landlord clients say is, well, if I tell them I'm terminating, they're not going to pay for the next month. Well, then we can evict them quicker, because if they don't pay for, let's use this example. Mike serves a 30-day notice. It says today you have to be out by May 31st. Great. We're in time. We're statutory compliant. Well, now he might not pay for May. May rent is due May 1st. Okay, well, if he doesn't pay by May 1st, post your 3-day notice. And now you can start the eviction even quicker than waiting till June 1st. Because in this case, if he pays in May and he doesn't leave, you have to file on June 1st. That's a month to month. If you have a lease, there's no notice required. If you have a lease and it says it's expiring May 31st, and there's nothing in the lease that says anything about renewals or anything like that, and they're not out May 31st and they're still in there June 1st, you can just file June 1st. So long as you have not accepted rent. The moment you accept rent,
Yeah, you get a 30-day notice.
it becomes a month-to-month tenancy based off the terms of the lease. So you have a month-to-month tenant. Every time you accept rent, you're extending the lease 30 days, right? 1 month. If you have a lease and it's June 1st and the lease is over and the tenant pays you for June rent and you accept it, you now have a month-to-month tenant.
And then you have to do a new 30-day notice to take them out for the.
And if you accepted the rent on June 3rd, guess what? You're not, and you didn't want them, but you took the money, you're not getting them out till July 31st.
Yep,
Right?
we have to do a new 30 days.
Because you have to do the 30 days. So the law is very specific on that. And attorneys will attack that. And it's one of the easiest things to attack on. I have represented tenants before. I don't represent a lot. I did it more in law school. I've done it in commercial cases. I represent tenants plenty. On the residential, once in a while, we'll get a call and there's a terrible landlord abusing somebody, and we'll take the case just to help somebody, right? On our side, I'm also very fair, right? I have, if my landlord didn't do things right, I tell them, listen, you didn't do it right. We got to resolve the case. We got to settle.
Yeah.
Listen, there's mold in your unit. What do you want me to do? There's mold. Are we going to resolve it and be fair, or you just go get killed in court and lose?
And pay attorney fees and pay.
Right. So at the same time, I'm not here just saying like we got to kick everyone out no matter what. We have to follow the law. That's our job.
Oh.
And if the law is clear that we're going to lose, I'm not going to tell my client, hey, let's go to court and go lose. We're going to try to resolve the case. Also, what we do a lot is try to provide finality. And then this is all if the case comes to me. If the case never comes to me, you're getting these guys out quick.
Yeah.
Because if I'm not involved, that means you got a default.
I only
no
call you
money.
if I need them. If I don't need them, then all my evictions go up. It depends. Like I said, it depends on the judge. Like there's one judge that she's sorry to, she's a bitch, Diana DeWhite, and I'll tell you,
I'm not agreeing with that whatsoever.
and I'm telling you, and she's making this so difficult that I need Stephen, and I don't need Stephen. But it depends on the judges. It's 1 out of a million that's like that. She does things by the book. But the thing is, for example, we just did an amended complaint because I filed the complaint right. The tenant didn't respond, didn't do nothing. But because of the LLC, the judge is requiring an attorney. That's why I got Stephen. Stephen entered the case. We did an amended complaint. We just posted it. It expired yesterday, so now Stephen's gonna get a default. Now the judge has to sign the default.
Right. I mean, there's technicalities in the law. Some judges are not as technical with these evictions because they've been served. Again, LLCs are allowed to file these cases themselves for 3-day notices. The law clearly allows a property manager to file these cases, 3-day notice cases pro se. What happened was, I'll give you a little bit of history and give you a little bit of the context. Florida law requires anybody other than individual. If you own the property in your own name or anything, you're allowed to represent your own self. But if you own a property in an LLC, a trust, a corporation, whatever, a partnership, Florida law generally requires an attorney to represent a corporation unless it's a small claims case under $8,000. Why? Because a corporation can't speak for itself. And the only person that's allowed to speak on behalf of somebody else in court other than themselves is an attorney, right? So what happened is many years ago, talking decades ago, these 3-day notice complaints are supposed to be very fast. They're supposed to be simple and easy. Why? Well, these property managers saying, why do we have to hire attorneys and it takes all this time? So the law was, the Florida Supreme Court said, okay, fine. We'll allow corporations with property managers to pro se to file these cases, which is what Mike processes. He's not an attorney. He's not telling you how the law works, right? He's getting the cases filed and done as quickly as possible.
I'm just here to help you guys out. That's it.
Because it's true. He does file and serve the cases a week or two quicker than I would be able to as an attorney.
And the more they're in it, the more you guys lose. So you have to think about, if I give it a training, I lose for a few months. I mean, I can lose 3 months of rent, and these judges don't care. Remember, like I said, I've been doing it for so long and I've seen it. If it's not because of one of them that needs help, then they do favors. But if it's for us, they don't care about us. Let one of their properties get one of the judges' properties get an eviction. You will see how they're gonna call the judge, hey, do me a favor, sign this quick. But because they don't care about us, and they don't, so that's why they take their time.
Yeah, I can't.
Hey,
I don't agree with any of that.
He can't, but it's true.
I don't agree with any of that. The judges are very overworked. We don't have enough judges.
You see,
they have thousands and thousands of cases. Some judges are slower than others. Don't get me wrong. That all happens. But it is true that your case is not a priority to that judge. That judge has priorities, and it's based off whatever that judge believes is most important.
Oh, and one more thing. And if they see the 3-day notice, they don't understand the 3-day notice, and they're not the breakdown, what they're gonna do is they're gonna get your file, and they're gonna put it all in the bottom. And when they got time to review your work and find out, to have a hearing and that gets even involved, that's what they're gonna get in your case. That's why I tell you, 3-day notice, make sure it's specific, just rent, and if you do have a lease where it says you could get late fees, then we could add it. But eliminate the late fees.
But I wouldn't even add it again. And he's right that the more complicated the 3-day notice looks, the more complicated the case looks, the more likely the judge is going to not grant defaults. And then it depends on what the tenant says too. The tenant's allowed to answer. A lot of tenants don't even answer. And when that happens, there's usually no issues whatsoever. Everything just goes through as quickly as possible. It depends what the tenant says. If the tenant files an answer and it's a company, even if it's an individual, once the tenant files an answer, then typically you've got to get someone like me involved because the court usually will not enter defaults by itself. It still can happen sometimes.
We can do a motion to strike and hopefully the judge grants it. There's a lot of times they do a motion to strike and then the judge does strike the answer. Sometimes the judge be like, I had a case, we'll sitting for 2 weeks. And I'm like, Steven had to do it because the judge didn't want to sign it. No, we do the motion to strike.
Yeah,
the tenant, what they got to do is go to the court, try to pay the court or respond to the court.
Right.
Once I see an answer, once the 8 days, okay, so let me explain how this works. So the law says that they have 5 days to respond. 5 business days. What I do with my evictions is I hold it 8 days because okay. So once okay, so let me know. So we put a video notice on the door. It expires. Say we do it on Monday. So we do Tuesday, Wednesday, Thursday. On Thursday, I'll call you and be like, hey, what's going on with your tenants? Or they haven't paid. I'm like, great. So Wednesday I'll see you. You sign the papers, then you sign, you're like the party manager. I'll give it to my girl, they prepare it. The following day I'll go to the court and I'll issue the summons. The summons says they have 5 business days to respond. But what I do is I hold it 8 days because I'll explain why. Because the courts are always 3 days behind. So if I drop it on the 5th day and the courts are behind 2 days, they can't enter the default until they catch up to the 5th day. If they see an answer, then me and you, we all think that it's going by the process, but reality, they're sending it back to you because I didn't do my proper paperwork. I never entered a motion to strike. So they can't enter the default because I didn't do that. So me and you think that it's going through the process, but no, we're actually losing 2 weeks because by the time you guys get it to your mail, find it, call me, Mike, I got this back, what's going on? Then we're losing 2 weeks. If I hold it 8 days, then the 8th day is the court's 5th day in reality. So at that time, they're going to tell me yes or no. If they tell me no, then I know that they're not going to send it back to you. Then I know that no is no. Or if it's a yes, then it's a yes. So that's why my evictions are a little, it's still faster than an attorney, but I hold my 8 days instead of 5 days. I learned this by a judge. This is what I learned by a judge. Because the judge always told me the courts are always 3 days behind. So they can't enter the default because they don't know if there's an answer or not. If they enter the default and they find an answer, then they screw up. So they have to wait until they catch up. Because remember, if they write in Spanish, then you're stuck because there's only one interpreter for the whole county. So and we have about North Day, South Day, Coral Gables, Caleb, downtown. What else? What else are we missing?
Okay. 5.
We have 5.
Yeah, it's 5. There's 40. There's between 30 to 40,000 evictions filed in Dade County every year.
Yeah.
Just in Dade County.
So if they write in Spanish, so if they write in Spanish, you're stuck because you lose about 2 weeks.
So they write in Russian, they get even more time.
That's you do.
Okay, this notice,
Okay.
is this an actual form?
The 3-day notice is a form.
Yeah, it's a form. There's a Florida bar
For
approved form that's approved to allow
let me see what I have.
like property managers are even allowed to fill it out. Right? You don't have to be attorney. You don't have to be an attorney to fill out the Florida bar approved form. Landlord can fill out whatever they want. If you're your own landlord, you can do whatever you want. From a realtor's perspective, from a property manager's perspective, you don't want to be filling out forms that only attorneys are supposed to do, right? You guys learn that very quickly for the real estate exam and things like that. You're allowed to fill out forms, right? So there are landlord tenant Florida bar approved forms that are meant for non-attorneys to use and fill out. Those are the forms that you're allowed, that as somebody like you as a realtor, you can say, hey, landlord client, here, property management client, these are the forms that are supposed to be filled out. You fill on the forms, or Mike has those forms and he helps you process them, fill them out, and serves them, right? So that's how that
Another
works.
thing I'm also getting, when it comes to tenants, it comes to security deposit. I always tell you on because they damage my properties. Yeah, but I'm like, where's the receipts? I don't have receipts. I always tell my clients, take pictures of before they move out, take pictures of the after you move out, and every receipt you keep. Because there tomorrow they want to sue you, and they tell you, judge, they kept $3,500. But no, judge, this is how they left it. This is how I turned it. This is my turnaround, and this is all the expense I had to fix. And the judge at that point will look at it and be like, okay, so you spent all this, you owe $35 only. But if you have no receipts, then you're stuck. Then you have to get security deposit. That's why I tell you all my clients, keep receipts. That's important because in court, that will show the judge what you're spending on, and then at that point, the judge will let you keep security deposits.
Have you guys run across any Airbnbs or daily rental issues too? You could?
Yeah, so that's a little different. So there's new law in Florida regarding squatters, which also applies to transient tenants. So, however, right now the process is not as fast as we would like it to be. So there's two different things, right? For one, you own a house. Maybe I actually had this happen last year. A client, realtor, a friend of mine had a listing in Hollywood. House is fully furnished, Brazilian buyers. They bought it 2 years ago. They refurbished. They actually did it Airbnb legally, allowed in that area, and it was listed. They stopped renting it Airbnb while it was listed. Client realtor, had it listed, wasn't getting a lot of action. He went to go check on the house. There's somebody in the porch brooming. Who's this guy? He calls me, saying, "There's people in the house." Like, what do you mean there's people? There's people in the house. Like, I locked it. I don't understand. There's people in the house. Like, who are they? I don't know. I'm gonna try. And then he said, "There's like all these people. One of them is a big guy who was being angry and get out of my house." He calls the police. The police say, "Sorry, nothing you can do." They told us that they live there. Here, they sent us a piece of mail that has the address. Sorry, got to go to court. So we had to do what's called an unlawful detainer action, which is something we still do a lot, which is basically if someone stays in the house, they're not a tenant, we can kick them out. It's the same process.
Sorry, at that point you need Steven because I cannot do.
That you can't do.
I can't.
However, the law recently changed, where now if that happens, you don't have to go to court. We have an affidavit, we fill it out, you go to the police department, to the county police department in your county. So Broward Sheriff's, Miami-Dade Sheriff, it's not police anymore at all. It's always been the sheriff office, but to us as attorneys, but now everyone calls it the sheriff's office. You go to the sheriff's office, And you can fill out a report, an affidavit, that if you lie in that affidavit, you're criminally liable, right? So it can't be someone you know that you let in. It can't be a relative. It really, literally needs to be someone you don't know. I believe that transient Airbnb tenants apply as well because that's supposed to be a hotel. If someone doesn't leave a hotel, they don't need to file an eviction. They can just call the police. So my position is it follows the same law. However, an unlawful detainer, I have to file it. You can probably get it done depending if they respond or not, 30 to 45 days. The sheriff process, we've done it a few times. It takes 2 to 3 weeks because you're filing a police report.
Yeah.
They give it to right now it's the Economic Crime Bureau. They get into detective.
No, they moved, the sheriff's already, the sheriff already took over.
No, I know the sheriff has.
No, I'm talking about the 601 people already took over.
Oh, so they have their own.
They already have their
So
own
maybe to be
department.
quicker, the sheriff has to have a detective go. They
Yeah,
have to investigate. They have to go talk to the people, see if they believe a crime is occurring. The crime being you're living in somebody's house that you're not supposed to be in, but not, oh, it's my friend. He didn't let him. No, you basically broke into the house and you're just squatting. A real squatter, not someone that you open the door for. A real squatter. If it's your friend, your girlfriend, your mother-in-law, whatever, that has to go to court. And unlawful detainer.
I had one the other day. They called me. Oh, the tenant left, but she left 2 people in there, and the 2 people that are paying my tenant's rent. I'm like, you file the eviction. Oh, who do I follow on? I'm like, you have to follow under your tenant, not the tenant that living there. Your tenant. Oh, but she left. It doesn't matter. The law says that she's your tenant. If she subleased the unit, that's not your problem. Your problem is your tenant. You have to follow, and then I don't know what happened. I'm not sure if
She
called you
never,
back.
she never call me back. either.
But she
They brought it up, so they lease it out to a tenant.
That's what I'm saying. Then you have to file the eviction under your tenancy.
So, well, 2 things. If you're a landlord, you should just be filing evictions under your tenant's name. If you are subleasing, right? You have a lease. Let's say you have a 3-year lease for a nice apartment, and you're allowed to sublease. The tenant, you better be allowed. That's what it should be. You're allowed to sublease the apartment, and the subleaser is not paying you. The subtenant's not paying you as who's a tenant to the landlord. You can evict. You don't need it doesn't have to be the landlord. Your lease is between landlord tenant and subtenant. You can evict them like this because you have the right to allow people going in and out because you're giving them access to the property. You have access through the sublease. So that's something honestly I've only done 1 or 2 twice. But yes, if your subtenant is not paying you, it's not the landlord's job to pay you because you're as the main tenant, you're paying the landlord rent. Landlord doesn't care, but you're allowed to evict the subtenant as a sub landlord.
So they're subleasing without permission, is that a 30-day without cure?
That would be a 7-day with cure.
Sunday with you.
Yeah. Get the subtenant out in 7 days. If subtenant's not out in 7 days,
No, man, that's between them.
no.
As long as they pay you
never have to
directly,
have
you
a
don't
contract.
care.
I mean, contracts only required, a written contract's only required under law for at least more than 1 year. If your lease is more than 1 year, it has to be in writing or it's not valid, right? But at least never has to be, I mean, you should always have a lease in writing.
Mhm.
Yeah. Yeah.
Okay.
Right?
That's illegal, you gotta have an agreement from the landlord.
Oh, you should have the landlord approve that. Most landlords wouldn't. But if you're doing that, and then that tenant that's leasing the room isn't paying, you as a tenant can evict. Yes, you can evict as the tenant. You have to
Even if
say,
it's not on the lease that you could sublease?
yeah, you can still evict somebody because I mean, you have to. You can't. The law doesn't allow someone to just sit there forever, right? So yes, if you rent an apartment for $2,000 and you have a roommate and the landlord doesn't know about it and it's not allowed approved in the release, but you as a roommate get paid $1,000 a month for your roommate, right? And then you pay your landlord $2,000, and then that roommate stops paying the $1,000 but then refuses to leave. The tenant under lease can evict that roommate. Yes.
But with the lawful detainer.
No, it would just be an eviction. It wouldn't be an unlawful detainer.
Still don't mind.
Yeah, no, you're talking.
No, that
Nah, I don't call you. Don't call me for that one.
Mike is.
Mine is a simple one, buddy. When it
For
gets
notices-
complicated, I give it a hit.
Busted.
Yeah, I no, I'll get Steve another night.
Well, that's what-
Give me
that's
2
what
minutes.
happens.
I'll
So-
put that real quick.
I mean, that's what happens, and I've gotten some pretty complicated cases where Mike knows, 1, by law he's not allowed to do them, right? And 2, he's not going to try to do something that 1, he can't do, or 3, he's not gonna do it right because it's complicated. So what he does, he speaks to them, he calls me, I pick up, I see Mike, I'm usually picking up, and we have a discussion. We discuss everything. And then I use Mike to get the notices out, get them served quickly, and whatever else. Sometimes in the middle of the cases, we gotta do subpoenas, we gotta do more notices, and that's what I use him for because I know he's quick and he'll get it done.
Have, this client of mine, she's a landlord.
Okay.
She rented one of her duplex. And then, I usually do like a 6-month inspection, and when I went last time, the lady had put like walls in between the houses. So
Oh,
like the dining room, they closed it
We
in.
we have one.
We have
Remember,
we've had a few of those.
no, Joseph.
We've had a few of those.
So we had one where the guy paid 2,000 because this. Okay, so let me explain how this process works. So you pay them 250 for 3 days. If they don't pay, then you have to pay the court cost. If it's one person, it'll be 695. If it's 2 people, it's 1,035. Depends how many people. If it's 3, it keeps adding up. Because how it works is the court charges 185 and then $10 per summons on how many people you have living there. So per people. And if that's the case, I have to do more work, so I have to add more. I have to add the fees for all that stuff. Now, when it comes to the sheriff, there's only Dade County. Every other county is standard, $90 standard. Just because Dade County is so bad and that everyone does evictions in Dade County, that the Miami-Dade Sheriff's has an express. That's 2,040. But you still have to, mind you, just because you pay 2,040 doesn't mean the judge signs right away. You still gotta go through the whole process. You still gotta go to 3 days, then you gotta do the 5-day complaint. When it's time for the sheriff, I'll let my client know you have the standard, you have the express. But when the judge signs, the turnaround time standard is good luck. The express is about 6-7 days to do the pull-up.
Yeah. And it really is good luck. The standard can be anywhere between 10 days to 40.
Not even that, 2 months, 3 months.
It could
probably.
be
Right now
over 2
they're about 2 months behind.
Yeah, they're pretty bad. So a lot of people, so if you have a tenant, a unit that pays $5,000 a month, you should pay the expedite fee. If you have a unit that pays $950 a month, okay, yeah, you don't pay the expedite fee,
That's my.
right?
Huh?
I mean,
Oh, no,
you say that, but
Well, you want
No.
you want to invest in Miami-Dade because Miami-Dade I have a connection with Judge.
no. So my
Yeah, so now you're safe.
no, but you said the city of Miami-Dade. No, Miami-Dade County. Only the sheriff, the county police. Let's just put
Yeah.
the sheriff, right? So again,
No. So for example, the only one that does evictions, the pull-up
It's
is
the
the
sheriff.
Miami-Dade Sheriff's Department, Broward Sheriff's Department. No county, no city police could do the pull. It has to belong to the Miami-Dade the courthouse system.
right? The
They have a
sheriff.
bureau. They have a bureau, so it belongs to the Miami-Dade Bureau.
No, the sheriff is the constitution. Again, Miami-Dade County, we used to not have a sheriff. We always had a sheriff. It was just appointed by the mayor, and we called it police, but it's always been a sheriff. Now we all have sheriffs in the whole entire state. The sheriff is a constitutional officer. They are elected official. So the court, the clerk of court, constitutional officer, elected official, or judges are elected officials, right? So the sheriff's office is the one who can do anything that the clerk of court or the courts tell them to do. City of Miami police can't do anything. Doral police can't do anything. I mean, each police, all the police can do is do trespass warnings and trespass if it's a trespasser. Once it becomes a tenant, residential property,
They'll send you to court.
they'll just say, sorry, go hire an attorney, speak to attorney, nothing we can do. And then when it comes time to actually pull it out, it's not the Miami police. It's only the Miami-Dade County Sheriff's Office in Broward, it's BSO, Palm Beach County, always. I mean, listen, the Miami-Dade County Sheriff's Department is, I think, the 3rd or 4th largest law enforcement department in the country. They have a $2 billion budget. It's a massive police department. But yeah, it takes, there's a big backlog. It takes
These cops, and I'm telling you because I know the people. I know sergeant. I know it.
BSO is much quicker. I would tell you that
Listen.
whatever they do, obviously Miami-Dade County is busier, bigger. Broward is not a small place. It's the 2nd largest county in the state, but they are much quicker.
Broward.
And they do not have an expedite service, but honestly, they don't need it. The longest I ever waited for a writ in Broward is probably 20 days. In Dade, it can be over 2 months.
Also, yeah. Months.
It can be over 2 months, especially once you get to Thanksgiving. Forget about it. They do.
I told my clients the 2 places to worst start is by November to January.
Yeah.
And then summertime, because judges go on vacation summertime.
That's true. And then two things. One, the sheriff will not execute writs like around Christmas, around Thanksgiving. At least they never have before.
Yeah.
I understand why. But also you're going for whatever reason, and probably because people are spending money, there's a lot of evictions that are filed around that time. And then the sheriff's not doing the writs, and then the judges are out of town, and the clerk has more people out of town because the clerk needs to file it. So things get really backlogged. And there's holidays. Every day that the court is closed, people are still filing cases. Everything's still moving. So then the backlog gets bigger and bigger and bigger. So it's a very, very difficult time to do that. And Mike, one thing we didn't discuss that I think is important is how we resolve some cases where I just told you in Miami-Dade County, if you want, unless you pay $2,000, it's going to take maybe even it's getting worse, maybe in 2.5 months to get them out. What I often do with tenants and with landlords say, listen, let's see what we can do, especially if it's a disputed case and we have to wait for a court hearing and all these things. We enter into stipulation that says, tenant, you agree to pay maybe this amount of money by this date, and you agree to leave by this date. And then what we do is we submit an agreed order, which gets
Signed by the judge.
judges much quicker because it's agreed.
And if they don't, the judge signs your. If they don't, just call me. I'm like, Steven, they do. The judge
Right.
call Steven. Hey, look, judge sign this, and the judge signs it.
And the writ will be automatically signed.
We always give them like 45 days. We always tell them
Even less.
45
No,
days.
yeah.
And we tell the owners, listen, it's better if you do that than go to court. Because if you go to court, you could lose, and then you have to file the case.
One,
again.
you could lose, you have to file the case again. And third, it brings finality. It says, no matter what, either they're going to pay or they're going to leave, or they're going to pay and leave. Or so it's a finality of the issue where you don't have any more hearings, no notices, not waiting. It could take 3 to 4 weeks just to get a hearing from a court. Judge is out of town for 2 weeks. They got trial 1 week. So again, these judges have thousands. Each judge has thousands of cases.
They have 10,000. They have 10,000 cases in front of them daily. And also, when it comes to the sheriff, there's 2 sets. When you pay the express and when you pay the standard. The sheriff, what do they want? They want their money. So what they're going to do, they're going to get this for this. So they rather make $2,200 than pay, and each call get like $700. Then just pay $115, and when the cops actually gain like $40. So those are their priorities. That's why I told my clients.
The express, my understanding, the expedite, they're using overtime, right? You're paying more because you're paying officers to go on their off days. They're paying overtime. They're making more money. They're happy. Where the normal fee is just the normal on duty, and this is a division. Like these are cops that all they do is do evictions. And BSO, I've spoken to the same deputy like 10 times. Hey, deputy, this, because that's his job. He goes around town. Sometimes with another officer, sometimes not, and does evictions. That's what they do. And the way the evictions work is it's pretty rare. Most tenants leave.
Yeah.
Because of 2 things. One, the police come and post a notice that says we're coming back the next day. They never come back the next day.
They do like 4 or 5 days. Like 4 or 5 days, they'll call you and be like, hey, we're scheduled for next week.
Right.
But tenants don't know that, so they get scared.
So usually they leave. If they don't leave, which I would say out of every writ that's posted, or every 10 writs, maybe 1, maximum 2 don't leave. It's pretty rare. If they don't leave, what do we have to do? The sheriff calls. They say, we're coming on such and such day. Somebody better be there from the landlord. If they're not there, the sheriff said, no one's here, they'll leave. Go reschedule, right? You got to wait. And now you're waiting again 60, 70 days. That's
I'll tell you how it works.
Number 2, change the locks. Number 3, if the tenant really hasn't left and you know that, you better have someone ready to start moving furniture.
Okay, so let me tell you how the cops work. They'll go knock on the door, and if they see someone there, they'll tell the tenant, listen, you have 5 minutes to get 5 things: your money, jewelry, weapons, paper, legal documents, and any jewelry, money,
Medication.
What else?
Medication.
And any medication. After the 5, that's it. They're like, all right, guys, get out. Unless there's who calls to be like, listen, you have 2 options. You can help them take yourself out, or stay outside and let them take yourself out. Once you guys go inside, the cops will tell you where to put it. You leave it there. It gets stolen, broken.
Not your problem.
That's not your problem. Just after 24 hours, you better make sure you go back and pick it up. Because at that point, you can get fined by the county, and you are responsible for that fine.
Yeah,
It's like 500. It's like $500. But the law gives you guys 24 hours for the tenant to come back to the property to pick up. Now, after 24 hours, they come back. You call the cops, and it's trespassing. but they're allowed in your apartment for 24 hours.
Not inside the unit.
Not
Just
inside the
take
unit,
your
outside.
stuff.
So
So
getting their stuff.
you take your stuff outside. It's raining, doesn't matter. Just take it outside. So
Huh? No, I can't do that because I'm from process server. It's conflict of interest.
so
And I serve all my eviction, I do everything, so I cannot.
and the law says that if you do a writ, you're not responsible for the property, unlike the law, which is not an eviction thing. But if a tenant just leaves and they leave all their stuff, the law doesn't say you can just throw it away. There's a process of notifying the tenant. You have to store the stuff. I mean, a lot of people
It's only
don't.
60 days. You call it for 60 days and
Right.
then your term. You tell them, listen, this is my appointment, so you can come pick it up. After 60 days, if they don't respond to you, you can throw it away. But you got to give them 60 days for them to come to your property and try to pick it up. 60 days. No. Okay,
No, this is completely different.
This is only the tenants leave, abandon your
Abandon
property, and they leave their stuff inside, and you know that they're no longer there. Then the law gives you guys at that point, to file an eviction, to get their stuff out of the property,
You're supposed to store it.
store it. You're supposed to get a storage for 60 or
And they
6
have,
days.
and they have to pay you for the storage. And you don't have to release the property. A lot of landlords don't do this. Don't get me wrong. But
Yeah.
so the way I tell my clients is like, this is what the law says. This is what you're liable for. You can do whatever you want. If it looks like a bunch of junk, the law does says is that if it's garbage, you can get rid of it. I think it's under like $500. But I have to, as an attorney, I have to tell you what the law says. So honestly, it's up to the landlord what risk they want to take. If you want to take the risk of this tenant coming back a month later suing you because you didn't properly notify them of their property, that's up to you. Have I ever dealt with that case
Nope.
in my life? Never. Right? But I have to tell you what the law says. And I tell you this because in an eviction, the law says it's not your problem anymore. You can throw away everything in there. Whatever they left, you can throw it away.
After
You can
24
sell it.
hours.
Well, no, if they leave it inside the unit, they don't take it out. It's their problem. You take out everything, you put it in the street, let the tenant pick it up. If they don't pick it up in 24 hours, you throw it away. Not their problem. Not your problem. It's you throw it out, sell it, whatever you want.
Like they abandoned the property.
There's a process. It's a statutory process. It's a little complicated. Written notice, storage, public sale. You can sell the stuff, and then you can pay yourself the storage fee and give the rest of the money to the tenant. No one does it. Don't get me wrong. I'm just telling you what the law says.
I've never had.
And none of my clients do it, and none of my clients have ever been sued because tenants that leave stuff don't care about the stuff they leave.
And they abandon the property, they don't give you.
I'm right, but unfortunately, the law doesn't care about that.
Oh, but also another thing that we gotta talk about. If say you have a security deposit and it's $5,000 and you see the damages that come up to $2,300, the law says you have to write a formal statement explaining what you cost, what the damage was, what you fixed, and send it to your last known address of what they could claim to your property. Not to, if you don't know where they live, that's fine, but to your property. Now, if they don't respond to that at that point, then you can keep security deposit. But you have to write a letter to your last known address that they lived, explaining what they could claim on security deposit. A lot of people don't do that.
Well, the law was recently changed a little bit on that, and the tenant's supposed to give you a last known address, and you're supposed to request it. If they don't give it to you, then what you're allowed to do is just send it to where they lived, because it's their responsibility to do the mail forwarding. On security deposit cases, I've been dealing with a few, and all honestly, I tell my landlord clients just give the money back. If they refute, just give the money back. It's not worth it. Most security deposits are $2,000 or less. I have a client now that did not do it, did not listen to me. She called me. Don't say names. She called me and she's saying, listen, I got the security deposit. I said, okay, well, why don't we just offer to give the money back? And we did. And the tenant had an attorney, and the tenant's attorney said, no, we want our attorney's fees. I said, listen, you should just pay it. Because right now nothing's happened. Just pay it this amount and end it. No, this isn't fair. I want you to represent me. I said, it's going to cost you more money for me to take the case than it is to just pay this right now. I'm not going to do it. I can't take the case. Okay, I'll do it myself because it's individual. And she did it. And she lost. And now she owes the attorney like $10,000.
And they'll forgive. That's no forgiveness. They will go after you for that money.
So I just had another security deposit case. My client, this is a big client of mine. They have 200 units. They were sued. They sent me the summons. There was a hearing like in 3 days. And I said, okay, let me look at it. I said, listen, do you have this? First of all, I said, without even knowing anything, look, the security deposit is $995. I'm going to charge you $500 to show up to court. So why don't we just, okay, fine. But do we need to pay the court costs? I'm like, listen, the court costs $225. Just pay it. All right. It's just not worth it. Okay, fine. We'll pay it. So, there's one thing from making claims. That's fine. But when a tenant starts refuting, just pay it. It's very, very difficult to prove security deposit cases. You better have the best pictures and the best video of before the tenant went in there and after the tenant went in there. And then people want to talk about blinds and painting. It's just not worth
It's
it.
not
Unless
worth
the tenant's like sledgehammering the place.
I had
it's not
one
worth it.
he got evicted and he Silvio.
Yeah.
And he got a hammer and started breaking every wall. He even broke the tenants. That's like next door. He broke that wall and the cops couldn't do nothing about it. That's why it's not worth fighting with these tenants.
Yeah, that too. But security deposit cases are losers.
Fell off, he just left it there, and he charged me $500.
Right. So the other part is I've had tenants come to me too. All right, it's $500. What are you gonna do? You're gonna spend $300 doing the filing fee and service. Then you're gonna spend 3 hours of your day going to court, sitting in line, waiting for the pretrial hearing. Let's say the landlord shows up. Then you're gonna spend another hour or two to court mandated mediation. Then you're gonna spend another hour or two to go to the final hearing. They're gonna hire an attorney maybe, and if they do it and they win, now you have to pay their attorney. If you win, good, that's great, but you don't have an attorney's fees unless you hired an attorney. And then good luck executing in the judgment and garnishing bank account. It's security deposit cases, but just not worth it.
It's not worth it, guys.
Now, if a tenant comes to me where they tell me, no, the landlord just emailed me the notice. They didn't send it via certified mail. Like, I love that case because I'm going to win 100%.
Of course.
And when there's the landlord, they're going to pay if you get a judgment because they have property. But
that's why I tell you guys, do not certify it. Post it on the door. Go take your time. If you're gonna do your own due diligence, go and post it on the door because it's your word against their word. And the judges are listen, and I'm letting you know these judges are not what it used to be. These judges are for them. I'm telling you, these judges are for them more than for us. Back in the day, they were for us, but now they see, especially in Miami. Miami, there's over 1 million people. They see everyone. If they really see everyone in the streets, we'll have a civil war in Miami. Alone in Miami, a civil war. So judges try to do everything possible to keep them inside your unit. That's why I say don't risk certified mailing. No, go to the property, take your time to do it, and go post it. Because at that point, you're actually on the property. But the judge, I was on the property, here's the picture. But now the judge, going to believe it or not, that's up to the judge. I can't tell you what the judge is going to do. Like I said, I have owners that don't even post their notices. Oh yeah, I posted, and they give it to me, and I file it. I don't know what's going on. I'm not you guys. I can only control what I can tell you. If you guys want to listen, you guys listen. And what happened was that guy had the neighbor had a camera. They never showed up, and guess what happened? He went to jail for lying that he posted an eviction, and he had dismissed the case, and the judge had to file it again. It's not worth it. I can tell you, pay the money, and I'm cheap. Like an attorney will charge you $1,700, and I only charge you, and I break it down. We do the 250 first. If they pay, great. Don't contact me no more. You got your money. Then, if not, then you pay me the eviction fees. And the attorney won't do that. The attorney will charge you everything up front. It's not worth it. And that's and property managers, like I said, big property managers, they're scared because an attorney lies and be like, oh, you have to follow with us. You have to use us. No, that's not true. And then because I'm not an attorney, I don't have a stupid ass bar license. They don't want to listen to me. It's true. It's true.
Again,
So what were you mentioning about the emails? If the landlord emails you.
Well, right. So that's on the security deposit
So
cases.
they gotta certify mail.
Certify mail. It's a statute requires.
Yeah.
If you don't certify mail it, it's useless. Can't FedEx it. Can't UPS it. Certified mail only.
What the
U.S. certified mail.
The breakdown.
There is a Florida bar approved form. You in a security deposit notice saying I'm withholding this amount because of these reasons. I'm returning if there's anything left over this amount, and then the tenant needs to respond. At the end of the day, the only way the tenant can force the money to get back is by filing a lawsuit. Some tenants just say, oh, it's not worth it. $500, it's not worth it. So we're not going to do it. But if the tenant fights, and the tenant fights, I usually tell my clients just give them the money because it's not worth going to court.
And another thing, now pro bono attorneys, you're free. The only thing I go is go pro bono attorney, and that's it. And those are loving to those are the ones that love to take these cases.
Well, the security deposit cases, the vast majority of attorneys they're not doing it pro bono. On the security deposit cases, you're doing it on contingency because we're only going to take a case that we love. For example, a case where the tenant tells me, oh no, he never sent it to me via certified mail. He even admits to it. He just sent it to me via email and that's it. Like I'll take that case because I can make thousands of dollars on that case if the landlord fights it. Thousands and thousands of dollars. So you got to send it via certified mail, or just give the money back, right? If there's an attorney involved in a security deposit dispute, 100% just give the money back. It's not worth the risk. It's just not. And then if you say no, I'm going to hire my own attorney to fight that, the whole case will just be about whose attorney is going to get paid the most money, because the security deposit is not. The security deposit is
Wait, brother, the attorney?
not.
Brother, the attorney?
No, he loves saying, I'm getting my attorney on it.
Right. So
That's what it is.
that's how those type of disputes. That's how those types of
Remember,
disputes
this
go.
game, who wins here are attorneys, guys. You have to understand that. Who wins here are attorneys. They don't. These judges don't give a crap about any of this.
No,
Let me explain how this works.
again.
Let me explain how this works. That's what these people will tell you. Let me tell you how this works. Remember, guys, this is all politics. So what happens is that the more money that and Steven could my dad's into politics. I know how this works. So Steven could say no, but I know how this works. The more that you guys spend out, the more money goes into the pot. The more that money goes into the pot, it goes to politics. I mean, all the judges, the key for these judges is to go downtown because the more they go downtown, is the more they get known because the politics is downtown Miami. That's the courthouse. That's where everyone gets known. Is downtown. So the thing is, the more that they put into politics for the politics, it's for the fundraisers, it's for this. So the more money that the attorneys pay out, the more money they give the judges, and you want to eliminate that.
Yeah,
Steven could not agree because, like I said, he's an attorney. But that's the reality.
yeah, listen, there's some judges are great, some judges you disagree with more often than not, but there's judges that are very clear that kick people out even when they don't want to because the law says they have to. I have a judge that
No, I'm not saying they don't, but eventually they kick them out. But
No,
think about
but I have a judge, for example.
Steven, we had a case in 2023 that the judge signed it the other day.
I get that. And
That's
again,
2 years that the guy's been in there not paying rent.
it depends. That's probably more in the client than the judge in that one.
But what I'm saying is that it's reality. It's politics. It's all about politics.
The judges have to follow the law, and that's what they do. They have to. They have to follow the law. Now,
I don't follow laws.
no, she's following the law more precisely than any other judge in the county is. That's why you're getting those delays. She's following the law unlike any other judge in the entire county does. That's why we're getting the delays. She's following it to an extreme level that no other judge in the county does. That's why those delays are happening. Do I disagree with judges all the time? Sure, of course I do. My job is to disagree with them sometimes. I'm forced to respect their opinion because that's the way the system works. I know some people don't want the system to work that way from very high levels, but that's the way the system works. And the only way I can get them to change their mind is to take it to an appellate court. That rarely happens in landlord tenant cases because it takes too long and too much money. I have been to appeals in landlord tenant cases before, but it's very, very rare.
Judges, they're officials, they're elected officials. They can do it, so they run their office the way they want. You can't control the way they want to run it.
To an extent, that's correct. I mean, they do have a boss, but to an extent, that's correct.
No, I'll tell you. Like I said,
I have obligations, right?
I'm not. I'll tell you how it is. Because, like I said, especially I've seen judges switch like really bad, and it's like sad because they're supposed to be for us.
That is correct. The judges are supposed to, they're public servants, and their job is to follow the law and allow justice to prevail. And sometimes justice is not nice. I've been in cases where there's a family of 3 kids and one of them's disabled and they can't pay rent, the judge says, I really feel sorry for you, but you didn't put money, I have to evict you. And that happens. I personally, I try to be sympathetic. When I have landlords that have cases like that, I tell them, let's try to give them time. The judges, I know a lot of the judges pretty, not well personally, but I'm in front of them a lot. And they do take notice when there's an attorney that often resolves cases. They're going to give you deference and they're going to respect you. So then when you have a bad case, there's a few judges that are in front of a lot, especially the judge Miami Beach, or my appellate case was with her. And every time I'm in front of her now, because she remembers me from that case and how I acted and how I was trying to get the case resolved, she respects my opinion and my judgment and will agree with me more because she's seen me, often and doing good work, right? So I often, and it doesn't get sometimes it's to get the tenant out quicker because you just heard how long it takes for the sheriff to do work, right? I often try to tell landlords, especially when we have families and things like that, let's figure out a way, let's not get an eviction record on them. And tenants will leave quicker
If we don't file anything.
because they know that if we do get a judgment, it's going to be very hard for them to get a place somewhere else. Because once their eviction record is there, it's there forever. There's no way to get rid of it. It's not like a criminal record where you can expunge and seal. It's there forever. So every time they get someone who looks their name up, they're going to see that eviction. So I often will be able to persuade tenants to say, listen, they know that it's going to take a long time. They know it's going to take longer than just take the judgment. But I persuade them, listen, let's dismiss the case, get out in 15 days, and you won't have an eviction on your record. And they do it. So there's a lot of different ways to do it. That's when I get involved. If I'm not involved, you're getting a judgment or the tenant's leaving really quick, right? But usually with him, you'll get your judgment very quickly. And then most of the time the tenant will leave
Before the sheriff
knocks on the door because they get scared, right?
Miami Beach courthouse is closed already. They closed that courthouse down.
No, they're temporarily located. They're going.
No, I already spoke to one of the clerks. They said that they don't know what they might stay in Kilo. The courthouse.
Really?
Yeah.
Wow.
Because
she's a good judge, Judge Silver. She's one of the best she's honestly probably the best eviction judge.
Well, it depends because with how she wakes up. If she wakes up in a bad mood.
No, I've had a lot of cases in front of her. She follows the law very well. That's Judge Silver.